3.25 pages of criminal history. That's not a resume, that's a rap sheet anthology. And notice, the judge immediately distinguishes between dismissed charges and the 14 felonies that weren't dismissed. Translation: this defendant is not walking in here with a clean slate.
Good morning. Good morning. Are you Crystal Boen? And Ms. Boen was previously in court, entered a plea of guilty to theft of property, a state jail felony. That agreement was for a 4-year deferred probation with a $1,000 fine, as well as restitution in the amount of $9,400. I've received the pre-sentence report. Have y'all all had an opportunity to review that report? And any additions or corrections or speak up, I'm sorry. I've got 1, 2, 3.25 pages of criminal history. There's a lot of stuff that wasn't. There were 14 felonies that weren't. At least 4 or 5 misdemeanors that weren't. I understand the restitution, and y'all know my position on that already this morning, but there's I mean, she's on probation right now in Sutton County, correct? Right. So do they know about this case? And what has happened over there, if anything? I can't understand you.
Hold up. Nursing school? With a record stack this high? Judges often question career paths when they clash with past behavior. Think about it. Would you want someone with theft, forgery, and drug charges handling your meds? The tension here is off the charts.
When? Are you really going to be able to go to nursing school with this type of criminal history? Another issue that I see on here also is the restitution, because it shows $9,400, but then it also, that was inside the bank, again it shows $500 from an ATM and $100 from a cash out, totaling $10,000, not $9,400. Is that correct? Well, it says 500 was withdrawn from an ATM outside the bank. Is that right? You know better than anybody. Okay. So possibly the other person that was involved did that?
Caught in the math trap. The defense is clinging to $9,400, but the judge tallies $10,094. ATM, Cash App, and all. Pro tip: in court, numbers don't just add up, they weigh down credibility. If you're off by even $600, the judge notices.
Right, it says, so the contact from Do Good said that the defendant withdrew the entire loan amount of $10,000, $94 from inside the bank, $500 from an ATM, and $100 from a cash app transaction. It doesn't matter if you did it or if the other person that you were with did it. Y'all were working together. So you're both, and what's the other status of the? Yeah. So I mean, if there was another person, you didn't give that information, then that's okay. Apparently the cops need it. So And so the probations in Sutton County, have they been transferred to Harris County? So you're going in person in Harris County. Okay. And so the state's decision to go forward with the agreement? So, alright, so here's what I'm going to do, Ms. Hogan. I'm going to find that you entered your plea of guilty freely and voluntarily. Can y'all hold it down over there, please? I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. I just don't know. I can't believe I'm even considering doing your honestly.
This moment right here is rare. A judge openly struggling out loud. It shows the human side of justice, balancing second chances with protecting the public. Viewers, would you lean toward mercy or maximum accountability?
I'm not. I can't. There's no way. It has to be straight probation. And I realize that that's going to potentially have some issues, but I can't with 14 prior felony offenses, same type of thing. So you do. Okay. How many do you think you have? Okay, you have lots of them that were at the same time for different. Yeah, you did probations for them. Yeah, a forgery of a financial instrument. Don't talk over me. March 3rd, 2008, Harris County, 180 days in jail, so that one was reduced. March of 2014, forging identification cards in Cuyahoga County, Ohio, 1 year probation. Same charge, same probation, so that's 2 in Ohio. March of 2014, aggravated theft in Ohio, another probation, the same date, but still another charge. March of 2014, attempted drug possession, pled guilty, 1 year probation. March of 2014, same thing in Ohio, possessing criminal tools, probation, all that was at the same time, but still different cases. November of 2014, forgery, 2 cases, got probations in those. I'm going to run out of fingers. March, another one, a theft, aggregated theft in Ohio in 2014. Then we go to Sutton County, Texas, and you have 1, 2, 3, 4, 5 continuous smuggling of persons for pecuniary benefit.
Human smuggling enters the chat. And not one case, 5. For context, smuggling for pecuniary benefit is no small-time charge. It can mean ferrying undocumented individuals across borders for profit. Suddenly, this isn't just theft, it's federal-level messy.
And that's the 10-year probation that you're on in 5 different cases. That's not correct. So how many cases are you on probation for in Sutton County? I understand it all. It doesn't run. That's not how it works. When it runs together, it just means you're serving it at this. I'm rejecting the plea agreement. I'm resetting your case for 3 weeks. See you back in 3 weeks. Y'all can talk about it then. Ma'am, this is not going to help. Well, looks like you did that, not me. I'll see you in 3 weeks. Come on, hold on, get her, don't let her go. Come back. Everybody heard it. Come back. You don't talk like that to anybody in this case because he didn't do this either. You did. He did a great job. I'm going to find at this time that your bond is not sufficient because of your attitude and because of your Well, maybe you shouldn't pass it your lawyer. Maybe you shouldn't have this attitude here in the courtroom. I'm going to raise your bond. What's the bond cost? Right now, after saying it's bullshit to him and acting like this in here, stop. No, you're going to make it worse. You're just going to make it worse. You should, when I told you a minute ago to stop, you should have stopped when I told you to. All right, I'm going to set your bond at $25,000. Go back with it later. Let's see how today goes. Ms. Boen, you were here yesterday for sentencing in cause number 25 DCCR 0026. Just so the record's clear, I rejected that agreement based on your criminal history, the fact that it was a deferred.
And there it is, the courtroom meltdown. Storming off? Cursing at your own lawyer? Bad move. Judges don't just hear words. They read attitude like evidence. That's why bond shoots up to $25,000 in an instant. Lesson: the courtroom is not a stage for outbursts.
Probation, I feel like with your criminal history, it is at this point, if you're going to accept responsibility, time for a conviction. You were going to be able to leave yesterday. There was an incident in the courtroom. Based on all of that, I was fine. Mr. Lewis asked that we bring you out today. Mr. Lewis, what is...
Yesterday afternoon, I was about one, she did apologize and she had got permission again to be these explained to her as far as what was the case, Jason was the firm. Kind of was that point that the probation was she was be on that time of probation. She was reporting to see things that they take her with the job. She wanted to still get out.
Mr. Hoffpower.
Yeah, he's a life. Maybe before.
Well,
the board wants to allow it to
yeah, well, that's what your argument was, just to continue for me to go forward. So, I mean, the most important thing to me, obviously, I don't know that you deserve probation at all with your criminal history. But as I said yesterday and today, it is time for you to have some responsibility and some consequences for continuing to commit felony. You know, it's great that you can finish a deferred probation, but at some point, you got to quit getting felony. You quit violating the law. And so I don't think that's fair at all. So what I can do, I have the paperwork still from yesterday. And if you guys would want to agree to a convicted probation, I can make that modification on this punishment recommendation, and then I can kind of reinstate everything up to the plea.
This is the turning point, the hammer moment. Judges often reach a breaking point. Why?
And all of that, so we don't have to go through all of that. So I'll reinstate everything we've done prior to today, make that modification on the paperwork, and go forward with it. Is that everyone's agreement? The modification will be a 2/5. It will be a 5-year probation. It will be a convicted 2/5. I am going to, I'm not inclined to order a fine because I want that restitution paid, so I'm going to mark through that. So with everyone's permission, I'll make that change, and that's what everyone's agreement is. Is that correct? And it's your I want to make sure you understand that this is now your agreement. So if I follow an agreement to give you 2 years in the state jail, probated for 5 years, order that restitution, you can't change your mind later. This is your agreement, is that correct? And the restitution will be that $10,000. And that's everyone's agreement as well, correct? Alright, then at this time, Ms. Bogan, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft of property. Sentence you in accordance with your new agreement to a term of 2 years in the state jail prison, but I'm going to probate that. You'll be on probation for 5 years. You're ordered to pay the $10,000 restitution and to follow all of the rules and conditions of probation. If you do this is still a good opportunity because you will be able to serve that 2-year sentence while you're out on probation instead of in the state jail prison. The other side of that, though, is if you violate any condition of probation at all, you will be brought back into court and you will be facing that 2 years. Just so you understand. I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, please don't answer this. Good luck to you, ma'am. Do you need my PSI? I printed it out. Okay, you've got everything. I'm sorry, I didn't hear it on PSI. You have them? Okay. Yes, ma'am. I appreciate that. Make sure that while you're on probation that you don't let those emotions also get in the way of you being cordial and doing what you're supposed to on this probation as well as the other one that you're on. That just in itself will get you right back. Even if you disagree with whatever they're ordering, if you disagree, you disagree. But you have to do everything they said you have to. That's just your call. You can go back to the bedroom. Thank you.